Criminal courts. Introduction. The two courts to handle criminal proceedings are the Court of Magistrates and the Court of the Crown. The actual court for the trial is decided by the type of crime associated with the charge. Summary offenses can be tried only at the Magistrates Court, indictable offenses can be tried only at the Crown Court, whereas triable offenses can be tried at either court. The plurality of suspects usually pleads guilty to the charge against them in both the Magistrates Court and the Crown Court. The court's role in these cases is to decide what sentence the defendant should be sentenced to. Where the perpetrator pleads not guilty, the court's task is to try the case and determine whether or not the defendant is guilty. The burden of proof lies with the prosecution, who must prove the case without a shadow of a doubt. The type of the court hearing is an adversarial one, with prosecution and defense presenting their cases and cross-examining the witnesses of each other, while the role of the judge is effectively that of the referee, overseeing the trial and ensuring that the laws are properly followed. The judge can't investigate the case, nor ask for further witnesses. 13.1 Magistrates Courts. Throughout England and Wales, there are about 400 magistrates' courts. There are district courts, so in many cities, there will be a magistrates' court, whereas large towns will have many courts. Each court deals with cases related to its geographic area and has authority over a number of criminal cases. Cases are considered by judges who may be either eligible district judges or unqualified lay judges. There is also a legally qualified clerk attached to each tribunal to advise the magistrates on the law. 13.1.1 Jurisdiction of the Magistrates' Courts. The courts had authority in a number of subjects as in criminal cases. They have a very substantial caseload and do the following. 1. Consider all of the reopened events. 2. In the Magistrates' Court, pursue all triable either way charges that it is determined should be dealt with. 3. These first two types reflect nearly 97% of all criminal cases. 4. Start with all indictable crimes at the first trial. Such proceedings are then referred to the Crown Court. 5. Deal with all the side matters connected to criminal cases, such as issuing warrants for arrest, the applications for bail, and decide. 6. Consider juvenile court cases where the victims are 10 to 17 regardless of sex. Civil jurisdiction. The courts of the magistrates also possess some civil jurisdiction. This includes imposing tax requests from the council and granting admission and inspection warrants to gas and electricity authorities. Legal disputes involving criminal defense orders and compliance orders. NB magistrate courts cannot issue divorces. Cases are pertaining to child welfare under the 1989 Children's Act. Seeking complaints regarding denial of selling of drug licenses. 13.1.2 Summary trials. These are the least severe criminal offenses and are subdivided into various class offenses, level 1 being the lowest level and level 5 being the highest level. Having rates allows for the establishment of a maximum fine for each stage, which is raised from time to time in line with inflation. The current maximum penalties derive from the 1991 Criminal Justice Act and are Category 1, overall £200, Level 2, £500, Level 3, £1,000, Level 4, £2,500, and fifth level, £5,000. Nevertheless, a corporation can be fined up to £20,000 by the magistrates for certain violations of environmental law and health and safety regulations. The current prison sentence that can be served in summary trial is 6 months, although the 2003 Criminal Justice Act gives power for this to be extended in the future to 15 months. The court clerk must check the name and identity of the complainant at the outset of any trial and then inquire whether he pleads guilty or not guilty. Most than 90% of the offenders plead guilty in the Court of the Magistrates, and the procedure is then associated with determining a fair punishment for the crime. Guilty plea. The usual sequence of occurrences in which the defendant pleads guilty to a summary offense is: 1. The CPS Crown Prosecutor or Deputy Prosecutor will provide a description of the case's evidence to the judge. 2. The criminal is asked whether he agrees with those details. If he does not, the magistrates may need to hold an investigation, called a trial in Newton, to ascertain the evidence. 3. The past record of arrests of the offender, if any, is submitted to the court. 4. Certain information is given to the court about the history of the offender, including his financial position. 5. The magistrates accept all appropriate reports. These could include a pre-sentence assessment written by a probation officer and/or a medical report on the mental health of the offender. 6. The suspect or his counsel will then be able to explain some issues that could convince the magistrates to grant a lenient sentence. This is called mitigating speech. 7. The penalty is determined by the magistrates. Not guilty plea. The process becomes lengthy and more complex when a suspect pleads not guilty, as both parties produce evidence to the judge. Since the burden of proof rests on the prosecution, the trial must continue generally by making a short statement explaining what the case is about and what they intend to show. Then witnesses of the prosecution will be called one at a time to give evidence, and each prosecutor will question what he or she has seen and heard. This is also the examination in chief. After a witness's chief examination is completed by the prosecution, the defense will then cross-examine that witness to test their evidence and attempt to demonstrate that it is not reliable. The prosecutor may also provide appropriate evidence, such as property that has been discovered in the defendant's custody or records that help establish the argument. The defendant can appeal to the magistrates at the close of the prosecution case that there is no case to answer and that at this stage, the case should be dismissed. This is because the prosecution must prove the case, and it must be discarded if its testimony does not establish a case. At this stage, only a very minor number of cases will be dismissed. The trial must proceed in the vast majority, and the defendant will have to show the court their facts. Typically, the suspect himself can give evidence even though he doesn't have to. Nevertheless, since the 1994 Criminal Justice and Public Order Act, the magistrates have been free to draw their own conclusions from the reality that the perpetrator is quiet and does not justify his hand. If the complainant gives evidence, the prosecution will cross-examine him, as can all witnesses to the defense. The defendant will call any person to give evidence that it feels can further disprove the argument of the prosecution. After all the proof has been given, the defense shall be entitled to deliver a speech attempting to point out to the magistrates the shortcomings of the case and trying to persuade them to acquit the defendant. Multiple statements are usually not allowed unless there is a point of law to complain over. Instead, the magistrates determine whether the defendant is guilty or not. When they prosecute, they can learn of his past record and can glance at records as well as receive a defensive statement in mitigation. Then they'll pass sentence. If the courts dismiss the claim, the defendant is free to go and cannot usually be charged again for that crime. And, if the convict can be retried, there is one clause. In a case-stated challenge, the defendant effectively argues against the acquittal. 13.1.3 Triable either way offenses. Plea before venue. The suspect is first questioned under the agreement before the location process if he pleads guilty or not. When he pleads guilty, then he has no right to ask to go to Crown Court even though the magistrates may still decide to send him for sentencing there. Mode of trial. If the suspect pleads not guilty, then the magistrates must hold hearings on the method of justice and decide where the matter is to be heard. In this, the magistrates first decide whether they think the case is suitable for Magistrates Court trial in them and whether they are prepared to accept jurisdiction. Under S. 19 of the 1980 Magistrates Court Act, they shall consider the nature and severity of the situation, their own powers of a penalty, and any representatives of the prosecution and defense. Cases involving complex factual or legal issues should be forwarded to the Court of Justice. Certain important considerations that can make prosecution more eligible for Crown Court include: where there was a breach of trust by a person, where the crime was committed by an organized gang, where the amount involved was more than twice the amount, the magistrates can fine the defendant. In unusual cases where the prosecutor is the Attorney General, Solicitor General, or the Director of Public Prosecutions, the magistrates must send the case to the Crown Court under S. 19(4) of the Magistrates Court Act 1980, if that is what the prosecution wants. In other cases, the wishes of the prosecution are just part of the matters that the magistrates must consider before they decide whether they are prepared to hear the case or whether it should be tried at the Crown Court. Defendant's election. If the magistrates are prepared to accept authority, the suspect is then informed that he has the right to select trial by jury, but the magistrates seek when he objects to this path. He is also informed, however, that if the case is heard by the magistrates and found guilty at the end of the case, the magistrates may refer him to the Crown Court for sentencing if they believe their disciplinary powers are inadequate. 13.1.4 Choosing trial by jury. As of 1997, in the plea before venue procedure, defendants pleading guilty to a triable either way offense at the Magistrates Court have failed to decide to go to the Crown Court. This is fair as there will be no appeal of the prosecution, so the defendants do not lose the right to a jury trial. Defendants who pleaded not guilty have been given the right to choose how to proceed with the prosecution. This was seen as an essential part of civil liberty since jury-by-jury courts are seen as defending individual rights. Not many suspects decide to go to Crown Court, though. It was notable that when all the defendants might vote to go to the Crown Court, fewer than 1 out of 20 decided to do so. Implications of choosing a jury trial. Many factors are involved in selecting the Crown Court as the court for prosecution by a criminal. The biggest reason for choosing the Crown Court is that a jury takes a verdict about guilt or innocence, and this gives a better likelihood of acquittal. Only 20% of the defendants who plead not guilty at the Magistrates Court will be found not guilty by the magistrates, while 60% of those who plead not guilty are acquitted at the Crown Court. That is when the Crown Court counsel refuses to provide evidence against the defendant. This may be because the prosecutor accepts that the defendant is not guilty by the time the case enters the Crown Court, or it may be that evidence has declined or refused to come to court, and the state provides no evidence to proceed with the proceedings. Other points to consider are the following. There will be a long wait before the trial, and there will also be committal proceedings in the Magistrates Court before the case goes to the Crown Court. Cases at the Crown Court are more expensive, but the defendant is also more likely to get legal representation through the Criminal Defense Service. If the defendant is represented, this must be by a barrister or solicitor with a certificate of advocacy giving rights of audience at the Crown Court. There is a risk of a higher sentence if the defendant is found guilty in the Crown Court. Research by Hederman and Moxon found that on the recommendation of their attorneys, most suspects who preferred the Crown Court did so, and the main factor was the higher chance of an acquittal. Nevertheless, there were many considerations that affected the decision, including a desire to serve part of the sentence in a remand jail, where the offenders were in custody. Should the right to choose trial by jury be kept? Holding trials at Crown Court is far more expensive than holding trials at Magistrates Court. Additionally, statistics show that many of the defendants who choose jury trial then go to Crown Court to plead guilty. This led to calling into question whether the accused should have the power to elect trial by jury in cases where they are charged with a triable either way offense. In addition, the fact that many crimes that used to be triable either way have been reclassified as summary offenses has already diminished this opportunity to a jury trial. These include the offenses of assaulting a police officer while carrying out his duties, driving while being suspended, and drinking alcohol. The government has tried to reduce the accused right to a jury trial in the past. In 1999 and 2000, in triable either way cases, the Labour government tried to pass laws abolishing the right of the defendant to elect trial by jury. The House of Lords ruled against the law change on both occasions. Later, in 2003, there were 2 provisions in the Criminal Justice Act, targeted at restricting jury trials. Another suggestion was for cases where an effort to tamper with a trial had already been made so that the jury had to be released. Where this happens, the defendant may insist that the jury be exclusively by the judge. That was enacted in S-44 of the 2003 Criminal Justice Act. The other proposal enabled the prosecution to apply for trial without a jury in lengthy or complex cases, or where there was a risk of interference from the jury. In 2012, the Protection of Freedoms Act abolished this clause of the Criminal Justice Act 2003 without ever having come into effect. The strong opposition to abolishing the principle to a jury trial is because this privilege is seen as a guarantee of the freedom of the people.